The doctrine of severability is a fascinating aspect of constitutional law that plays a critical role in how we interpret legislation. Imagine a law as a complex machine. If one part malfunctions, does the entire machine need to be scrapped? Not necessarily. This doctrine allows courts to strike down only the problematic parts of a law, while keeping the rest intact, provided that the remaining provisions can still function effectively. This principle stems from Article 13 of the Constitution, which states that any law violating fundamental rights is void to the extent of that inconsistency. So, if a law is challenged in court, the judges must assess whether the invalid part can be severed from the rest. They ask themselves, is the remaining law still coherent? Does it make sense without the unconstitutional section? A landmark case that illustrates this doctrine is R.M.D. Chamarbao Gwala v. Union of India. In this case, the Supreme Court dealt with a law regulating gambling. The court found that certain provisions were unconstitutional, but rather than throwing out the entire law, they struck down only the invalid parts. The rest of the law remained valid and enforceable, demonstrating the court's role as a surgeon, carefully excising the flawed sections while preserving the healthy parts. This surgical approach is crucial because it ensures that laws can continue to function and serve their purpose, even when parts of them are found to be unconstitutional. However, there's a caveat. If the remaining provisions are so intertwined with the invalid part that they lose their meaning or effectiveness, the entire law may be scrapped. So, the doctrine of severability emphasizes the importance of balance. Courts strive to maintain the integrity of the law while protecting fundamental rights. It's a delicate dance of legal reasoning, ensuring that justice is served without dismantling the entire framework of legislation. In essence, the court acts thoughtfully, preserving what works while removing what doesn't, ensuring that the law remains a living document that adapts to our evolving understanding of rights and justice.